Good afternoon. Hi, I am Max Belke, and I'm the Director of Budget and Tax Policy in the Washington, D.C. office of NCSL. And NCSL staffer, a primary staffer on the issue of online sale or remote sales tax collection. We have a very esteemed panel up here today. To my left is Jason Brewer with the Retail Industry Leaders Association. To his left is Director Dan Noble of the Wyoming Department of Revenue. And to his left is Gregory Mattson, who is the Executive Director of the Multi-State Tax Commission. We'll explain what those, a little more about those two organizations here in a second. So in general, why are we here? We're here because in the, I mean, like, that's an existential question. Like, why? Okay, we're here in this session this afternoon because we love to talk about taxes. Now, we're talking because of the growth in the rapid growth of online commerce has fundamentally changed the way that we shop and the way that we work, and quite frankly, how we socialize. And for the last 6 years, year over year, e-commerce has grown 15%. And depending how you measure it, it's either 9% or 11% of all retail sales. And I believe the fastest growing form of commerce is actually mobile commerce, which has grown 50% year over year. So now we can't even wait till we get home on our computer. We have to buy it right now where we are. And to put that in perspective, and where this goes back to is the 1992 Quill decision, which said that a business had to be physically present in a state in order for that state to be able to require that business to collect or remit that state's sales tax. Well, it put that in point of perspective. The first text message ever sent was sent in 1992 in Finland. Now I can, stream live TV in my office when I'm on a conference call, and on my phone. I mean, and in 1994 wasn't until that was the first year that the first secured internet retail transaction occurred, and it wasn't until July of 1995 that Jeff Bezos actually sold a book out of his garage. Now his company sells a few more things, and that's really where we are and try to address this issue, which is also an issue of fairness for retail. It's also an issue of ability of states to exercise and be able to enforce the tax laws that their constituents, voted them for. That being said, so I'm going to kick over here to Greg Mattson actually to start out about the Multi-State Tax Commission, just to give a little overview of the perspective that you're going to be coming from here today.
All right, thank you, Max, and thank you for inviting me to be on this panel. I just want to briefly talk and describe the Multi-State Tax Commission because we're kind of weird. We were started in 1967 as an effort by the states to protect their tax authority in the face of previous proposals to transfer the writing of key features of state tax laws away from the state legislatures and to the federal government. For that reason, the Commission has been a voice for preserving the authority of states to determine their own tax policy within the limits of the U.S. Constitution for 51 years now. Our mission is to achieve fairness by promoting compliance and consistent tax policy and practice, and to preserve the sovereignty of state and local governments over their tax systems. It's hard to describe. We're not an NGO. We call ourselves an intergovernmental state tax agency. Probably easiest to think of us as an instrumentality of multiple states. We can't tell the states to do anything, our members. We are advisory. In that sense, we serve the states as an adjunct to their own departments of revenue. For purposes of this discussion, Max, I'm going to mention one of the many things that we're involved with. We have a uniformity committee in which all states that meet with us can participate. And the Uniformity Committee studies and proposes uniform tax statutes and regulations. For example, they did a uniform doing business or sales tax nexus statute with the participation of a number of states. Our states are both streamlined states and non-streamlined states. And we work closely with other state tax organizations, as well as NCSL, NGA, practitioners, and taxpayers. And that just kind of gives you the perspective. And I was going to say, Normally, this is probably the most piebald of the maps that you would see, but I can't say that in this presentation.
Well, thank you, Greg. And actually, you said Streamlined. I think, Dan, that enters you. So Streamlined, can you give us a little background on what Streamlined sales tax is, how it came about, and what it is today, and, and your role in working for them?
Okay. Good afternoon, everyone. I'm Dan Noble. I'm the Director of the Wyoming Department of Revenue and currently serve as the President of the Streamlined Sales Tax Governing Board. I was not supposed to be here today. Craig Johnson was actually going to do this presentation. A few days ago he called and said he had an emergency at home that he needed to deal with and asked if I'd stand in. I said, sure, what am I supposed to do? And he said, oh, just give the same presentation you always give. Well, it's a little different today because I'm going to talk a little bit about the history of Streamlined. I became involved in Streamlined sales tax in late 1999, and there were a few meetings prior to that, but I've been involved in it for a lot of years. The purpose originally was to look at the Quill decision and try to, as states, address some of the issues of complexities that exist in our disparate tax systems and try to develop some levels of uniformity and simplification where we could. In order to do that, we looked at ourselves as tax geeks, if you will, and felt that we needed to include other people in this, and that involved into allowing and asking for businesses' input into this. We have had a great relationship with the business community and involved them every step of the way with the Streamlined sales tax agreement as it was being drafted. We involved the legislature at an early time as well to try to get a feel for what is feasible to actually deal with as it relates to simplification. And we came up with a group of principles, things that seem to be very important to the business community and to the states as well. There were a number of things that are even mentioned in the Wayfair decision, one of them being state level administration of the tax, developing common tax bases between state and local government, simplification of tax rates where possible, and some guidelines on how and when to actually allow rates to change. One of the things that surprised me early on is to recognize just what kind of a burden we place on businesses when we change our tax rates. In the state of Wyoming, we had 5 different elections that could actually change a tax rate, and those elections occurred on different days throughout the year. So in order to really find out, even for our Nexus vendors, when a tax rate would come in place, you needed to look a lot to try to figure out when a rate would change. One of the simplification measures of the Streamlined sales tax was to say that there are 4 times during a year when you can actually change a tax rate, and it's the beginning of each and every calendar quarter. That doesn't sound all that big of a deal, but when you consider that you almost have to look in 44 different states 365 days a year to find out when the tax rate changes, it becomes a pretty big deal. And so it became a very major simplification. The issues associated with when you have to report taxes. We looked at a lot of different things to try to develop a simplified tax structure. And the Streamlined Sales and Use Tax Agreement was born out of that type of work. There's an awful lot of people throughout the history of the Streamlined that have put in countless hours associated with trying to develop this agreement, and 24 states have actually adopted the mechanism, if you will, although still retaining their own sovereignty and recognizing that there are some concerns associated with even the agreement as it exists today. But that's pretty much what has happened throughout the history. At one point, there were a number of congressmen that tried to, and senators that actually tried to develop legislation that would kind of mirror some of the tenets of the Streamlined Sales Tax itself. The Marketplace Fairness Act was passed in 2013 in the Senate. It has languished on the House side for a number of years. There was an attempt to try to take and tweak the Marketplace Fairness Act with the Remote Transaction Parity Act. Had a few differences, but essentially the same type of a bill. And we finally had one state that basically said enough is enough. We need to basically get this in front of the court because it's not going to happen in Congress. And kudos to South Dakota for taking that lead. It has resulted in the Wayfair decision, and I guess the next step is to try to figure out what do we do next.
Thanks, Dan. Jason, you know, where do you come in this from the retail perspective, and what are your initial thoughts here before we dive into this a little bit more?
Sure. Well, first, thanks to Max, Neil, and Jake, and the whole NCSL team that have been terrific partners on this issue for quite some time, probably longer than we wanted to be on some level. But, you know, so often on this journey when we encountered a roadblock, we worked together to find a way around it and go into a new direction. And it has been a terrific partnership. We're certainly sympathetic to the plight of state and local governments in this fight, because you're responsible for paying for police and fire and roads and schools. And that was something that obviously was something we were sympathetic towards and supported. But for the retail community, this has always been about free markets and the government thumb that was essentially on the scale when it said to an online company, you don't have to charge the same sales tax that the brick and mortar store has to charge. So for us, for the last 2 decades, it's been a free market issue. We felt the marketplace has been broken, and we're very excited now to have a Supreme Court decision that clears the path for states to correct this inequity. We think it's a win-win for state governments, for your local retailers, and so we're very excited to work with you on language that mirrors what Senator Peters introduced in South Dakota and what some other states have done on the marketplace side to close that loophole to ensure that you get the revenues that you need with your state sales tax, and retailers have a level playing field on which to compete. So we truly view it as a win-win, and I would encourage all of you, if you haven't at this point, to reach out to your local state retail association. They should have language that they've worked with some of the national groups on, and they're eager to partner with you as well and to talk to your colleagues who maybe haven't been focused on this, but we really look forward to working with you over the next year or so to implement this nationwide. So thank you very much.
Great, thanks. So let's go ahead and dive into how we got to Wayfair, and then where we are right now, and then how we look ahead. So what did we get here? Well, in 1992, the Supreme Court said that Quill versus North Dakota, in addition to saying that you'd have physical presence in the state, but it also said, Congress, this really, you should do this, you should take care of it, it's your issue to take care of. So, you know, it came about, and as Senator Bramble, former NCSL president from Utah, said during the Judiciary Committee hearing this past Tuesday, a week ago today, it is Tuesday, right? It's been a long week. You know, Congress had the Opportunity Act in 26 years, but simply didn't. You know, this goes back to the 60s. The Quill decision is what led to the Streamlined Sales and Use Tax effort that Dan talked about. In 2013, the Senate passed this, you know, 69 to 27, but for over 5.5 years was never even brought up for a hearing, let alone a vote in the House. And then the Remote Transactions Parity Act, which was introduced in the House, which addressed some of the concerns that were raised by the House Judiciary Committee, was also never brought up for a vote. So it was rather frustrating for states, which is why they got tired of waiting. And I like to start here. I like to start a little different spot. I like to start in 2010 with Colorado, because I think this is you know, 2010 when Colorado said, look, we know we can't force companies that don't have physical presence in here to collect our taxes, but we would get them to report the taxes that are owed. And what they said was, if you're not collecting and remitting into our state, if you meet these certain thresholds, then you have to report to the state and to the consumer in the state what they bought. And this was challenged, and it made its way up to the Supreme Court first, really on the Tax Injunction Act on an actual legal issue. But what came out of it, and then it ultimately came back up a second time, and the Supreme Court denied it, so the law, they essentially found that these reporting requirements were constitutional, and other states have followed them since. But perhaps most importantly was a concurring opinion that came down by Justice Kennedy, who wrote about the MAB rule, that it was a case questionable, about Quill rather. It was a case questionable when decided. Quill now harms states to agree far greater than could have been anticipated earlier. This was like, okay, well, we need to do this. He agrees with us. We need to bring the right case to do it. And states heard that. Actually, and Senator Peters, who is with us, I'll get to more of her in a second, the NCSL State Local Taxation Task Force met later that year in November, following the concurrence from Justice Kennedy. And it was, you know, like typically this is how things happen in Congress. Nothing, 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 nothing. Huge bill nobody reads, law. And you know, they should update Schoolhouse Rock. But you know, and so what we said is that there was a possibility that sales tax election legislation could be included in the year-end omnibus package. And but we were very skeptical that would happen, and sure enough, it didn't. So Senator Peters said directly, if we're going to do it, we need to have, you know, legislation to challenge Quill. We need to have a bill ready January run and be ready to rock and roll because committee hearings start the second week in January. She was saying, I'm ready to do this, and she was not lying, and we'll get to that in a second. So January, we met in Salt Lake City as part of the NCSL Executive Committee and spent the NCSL State Local Taxation Task Force met, and we discussed this for over half the meeting on what states could do, because pure the frustration matter. And that meant anything from expanding Nexus to be able to collect more taxes constitutionally, or to simply challenge Quill. And states were across the board for obvious reasons. But what resulted out of this, you know, effort and discussion, really the focal point was in South Dakota, which I find kind of ironic considering that the previous case was in North Dakota. Landmark decisions out of the Dakotas. And what Senate Bill 106 says, and it's one of the most unique pieces of legislation I've ever read. I mean, there's 100, and I know that because I have a lot of fun in my free time. But what it says is that if, you know, we don't care if you're indifferent to if a physical presence in the state. If you sell more than $100,000 a year into our state or have 200 separate transactions, you have to collect and remit. And that was a very small portion of the legislation. There was actually, I would say, to constitute the majority of it was actually the findings, which was very unique. You put in there, this is what this is why we're doing this. This is why we believe we're right. And also, if and when we're to be challenged, meaning we know we're going to get sued, we're going to direct the state's judiciary to take this up and consider it as fast as possible. So it was meant to fast track the way through. I think what is in addition to them directing the judiciary as expeditiously as possible, which is rather unique, it says it does not apply any of the provisions retroactively. So Senator Heidi Heitkamp from North Dakota was the tax commissioner in 1992 when the Quill was decided, and she is a strong, you know, adamant believer in the fact that the reason North Dakota lost is that during oral arguments, the North Dakota attorney actually said, oh, we can apply this retroactively. So South Dakota said, no, we're going to put this in here, and we're going to just go ahead and get rid of, make sure that's not an issue to begin with. You know, Senator Peters, the bill legislation was introduced on January 27th. In March, it was signed into law. A few days after that, the DOR sent notices to over 200 retailers they believed had met the 200 transaction or $100,000 thresholds into the state. And April 28th, the state filed, this is an expedited timeline, obviously, then we also countersued as well. March 6th, the South Dakota 6th Judicial Circuit ruled that the bill was unconstitutional. This was not a surprise. The state went in there and said, we agree with them, we're wrong. We need to go to the next level. But at the next level in South Dakota is straight to the South Dakota Supreme Court. Unlike most states, there's only 2 levels in the state's court system, which is another reason why it moved as fast as it did. So it moved along. The South Dakota Supreme Court on September 13th said the same thing, and it was one of the most friendly, you're wrong, you can't do this opinions you could read, which is, we agree with you, state. If we could, we would say you're right, but we're not the Supreme Court. But, we would gladly take that job as well.
Can I add something really quick?
Sure.
I think similar to the retroactivity issue that you mentioned, this was also pretty important to the case because in the North Dakota case, North Dakota had overruled a previous Supreme Court opinion, and the Supreme Court doesn't like that. And so going the alternative route, actually losing, made a lot more sense to approach the Supreme Court rather than snubbing your nose at a previous decision and saying you guys must have been wrong when you decided this 20 years ago. So much like retroactivity, there was an important sort of nuanced point to how this case got to the court that set it up for success.
Exactly, thank you. And so on October 2nd, the state petitioned to the Supreme Court, and on January 12th of this year, the Supreme Court said, okay, we'll take it up. So in less than 2 years from when the bill was introduced, the Supreme Court had granted a hearing. That's pretty quick. April 17th, they heard oral arguments were heard, and which was very interesting. Some of us were in the room, and it was a lot of things were brought up between, a lot of considerations between the Dormant Commerce Clause, the state sales tax simplification, retroactivity, technology, how that is advanced. Are there small seller thresholds? Are you protecting the really small guys? Those kind of issues were brought up, and I just want to, start by asking the panel of, what do you think was really went into the court was thinking and their judgment, and what were they really weighing here when they went to go decide this?
I'll give it a shot anyway. I think, as Senator Peters said yesterday, there was an issue of fairness associated with this. The court had to recognize that commerce has evolved significantly since the Quill decision and even before that, the Bellis Hess decision. And to recognize that by creating the physical presence standard, they were actually creating a discriminatory tax themselves, because it allowed a certain taxpayer to receive benefit that others could not. And I think that's very well stated in the case, and I'm going to read an excerpt from the court decision. It is a little lengthy, but I think it's important to this very issue. And this is on page 16 of the decision. It says, in essence, respondents ask this court to retain a rule that allows their customers to escape payment of sales taxes, taxes that are essential to create and secure the active market they supply with goods and services. An example may suffice. Wayfair offers to sell a vast selection of furnishings. Its advertising seeks to create an image of beautiful, peaceful homes. But it also says that one of the best things about buying through Wayfair is that we do not have to charge a sales tax. What Wayfair ignores in its subtle offer to assist in tax evasion is that and this is from the court, is that creating a dream home assumes a solvent state and local government. State taxes fund the police and fire departments that protect the homes containing their customers' furniture and ensures goods are safely delivered, maintain the public roads and municipal services that allow communications with and access to customers, support the sound local banking institutions, credit transactions, and courts to enable collection of the purchase price, and to help create a climate of consumer confidence.
Max, I'm not sure about all the justices, but I have to think that Justice Kennedy was thinking about retirement. When you look at his concurring opinion in DMA, which essentially sort of lit the fuse for the states to really think about making a run at Quill and really a run at Bellis Hess, which Quill was a run at Bellis Hess. And then, you know, Wayfair came out, and I don't know, it just seemed awfully close. It was a matter of days, right? And he announced he's going to be retired. I had a sense of like, he's thinking, finally, I can retire. I've fixed this problem. So that's my impression. I think he was thinking about retirement.
Oh, interesting. Those are two very different responses. So in regard to the decision, so on June 21st, the Supreme Court ruled, and it was 5-4. The court did find that the economic and virtual contacts are enough to create a substantial nexus with the state, allowing the state to require collection. What was also interesting, though, in the dissent, which was written by Chief Justice Roberts, he wrote that Bellis Hess, which was the preceding case in 1967 to Quill in 1992, he wrote that that was wrongly decided then, that physical presence was wrongly. So it was 9-0 saying that physical presence is not a good measuring stick in determining whether or not a business has availed themselves to your state's market and whether or not it should have to follow the same rules as your in-state's businesses.
Hey, Max, I also think that it's important to understand, you know, Max spent some time going through the history of since Bellis Hess and the state struggling with this issue, and what Congress has been considering this issue since Bellis Hess and certainly since 1992. And so Chief Justice Roberts in the dissent also wrote what I think is the understatement of the year when he said, Congress has in fact been considering whether to alter the rule established in Bellis Hess for some time. So, you know, there's a lot of interesting stuff in the dissent, but I don't think we can emphasize enough that it was unanimous that Bellis Hess and Quill were not the right rule.
That the 4 dissenting votes were, we believe this was wrong, but that this was still, Congress should be the one to fix it. And to your point, yes, quite an understatement.
And I think there were some folks that thought that Sotomayor and Kagan were perhaps holding to the principle of stare decisis for future cases, that they may have been with us on this, but they wanted to sort of draw that line in the sand that the court shouldn't be in the business of overturning precedent because they see other cases coming down the pike, especially now that there'll be a new Supreme Court justice coming that will make the court, in theory, more conservative.
Are you suggesting there's politics involved with the Supreme Court? Moving on, so what the court also said, and this is more back to what Dr. Noble was saying, the court said that physical presence is no longer the requirement, but that doesn't mean that the Commerce Clause and that undue burdens on interstate commerce can all of a sudden, that jurisprudence and legal case, it just went away. It was traditionally apply Commerce Clause to interstate sales, but now you just don't take physical presence into account. So can any state on day one all of a sudden start collecting? Most states no. I mean, it has to be certain things and do what South Dakota did. One of this is, you know, as outlined in, you have a safe harbor for small. These are examples of things that South Dakota had done, which the court looked at and said, South Dakota, you've done these things, and therefore we believe you've resolved the undue burdens. The Supreme Court doesn't create law. It interprets it. So what it was saying is that these things that South Dakota, enacted actually address the undue burdens as outlined in Quill. It didn't say you have to do them. It doesn't say whatever. But it's saying if you do all of these things, you've addressed those undue burdens, which include small seller protections, not going retroactive in tax enforcement, that you only have a single statewide place where taxes are remitted and collected and where audits take place, relatively simplified rate structure and uniform definitions and rules, at least across the entire state where that tax is going to apply. And just in accordance with this as well, the NCSL, the State and Local Tax Task Force, met a week after this decision and actually adopted a set of principles that states can look at to guide implementation as they go forward, which is on the NCSL State and Local Taxation Task Force webpage. please let me know if you can't find it. Let me know. But to that, other comments? I mean, what else do you see in the opinion here? That am I oversimplifying it?
No, I don't think you are at all. And I would just say, I think there is, I wouldn't say universal agreement, but in this crowd, probably near universal agreement that Congress should not address this at this point, that they don't need to get involved. The only thing that invites them to get involved are states doing bad things. And so following those sort of guideposts, no retroactivity, some sort of small business exemption, simplification, et cetera, those are the things that ensure Congress does not come back and meddle in this again.
I think we have an opportunity as states here, but I think that there was some instruction as it relates to what we need to do as states from the court themselves. One of the things that they describe are the other components of the complete auto decision and how it still plays a major issue on what states' authority how it lies and where it ends. It says modern precedents rest upon two primary principles that mark the boundaries of a state's authority to regulate interstate commerce. First, state regulations may not discriminate against interstate commerce. And second, states may not impose undue burdens on interstate commerce. The court didn't rule on either of those because it wasn't presented to them. We still may face some issues as it relates to this, this part of the Commerce Clause. So I think it's very important that we recognize, yes, they did talk about a lot of the simplifications that the Streamlined project provided and that the state of South Dakota did in their bill. The small seller exception, the membership in Streamlined, all of the simplifications that are part of that agreement, but it didn't rule on that. It basically provided guidance, and it remanded the case for further discussion associated with those issues related to the Commerce Clause. So this isn't over yet. I think it's one of the things that we need to be very cautious of moving forward. We need to be very deliberate about how we approach this. I'm concerned about it mainly because I'm in the middle of the same thing that the state of South Dakota is facing. They have a law that places an injunction on enforcement of their case until it is resolved. It's been remanded, so they're still in the fight, the same as Wyoming. We have an injunction in place because we sued the exact same parties, and we have to wait until that is somehow resolved. So there's some concerns for us, obviously, but I also recognize that there was some pretty specific guidance in the decision that points to the fact that some of these simplifications may, in fact, eliminate the burdens that are out there that were considered, that may be considered undue burdens.
Yeah, I think it's important to recognize that the Wayfair case is not over. It's not final. In fact, so it's been remanded to the South Dakota Supreme Court, and I think the expectations are that they will send it back to the circuit court, the trial court, which issued the injunction blocking them from implementing the law. But because the Supreme Court simply had the physical presence issue in front of them, but when you read the opinion, you can't help but think the decision would have been different if the elements of South Dakota's laws were not there. So while the opinion does not create a list of requirements or a checklist that states must follow, you could do a lot worse than to just pattern what you're going to do after what South Dakota has set up. Last week, George Isaacson, counsel for Wayfair, said to me, well, he said it to the MTC, but I was in the room. He said, Wayfair is not the end, it's the beginning. And the result in Wayfair doesn't make the efforts of Streamlined and other organizations and MTC and NCSL efforts at state simplification of sales tax systems less important. It makes it more important, okay? Because now that physical presence feder on the states is not there. And everyone is watching what the states are going to do.
I agree. This is just generally, I'm going to be briefly here, and it depends how you count and how exactly you define these laws. So I go ahead and previously saying, but this is generally where states are. In the last several years, the amount of calls that we get at NCSL from states from all over the country on this has been rather remarkable. And you know, so economic nexus laws, these are establishing the amount of economic activity into a state, and that's the South Dakota style bill. Those are the states in red. The states with green are the ones that are notice and reporting, such as Colorado. You know, both economic nexus and notice and reporting are the blue states. And there's nuances to each of these and how they define it. Each law is different, just like our states are. So, you know, I have to check with each state individually. Software nexus are what Ohio and Massachusetts have, and this is the idea of cookies. So everybody, you know, recently, have you had to like push OK for all the new cookie, you know, on a website? It's OK because of the new European rules. Well, those are cookies that are on your phone or on your computer, and the idea is that's intellectual property owned by the business, so therefore that business has property located in this state. And I think we would have seen a lot more interesting cases going down this avenue next year if South Dakota had not prevailed. But the next set of law, and I think this slide here is important because this is where states are going, and they were going here regardless of what happened in Wayfair. It has to do with marketplaces. So marketplaces are forums in which you have an intermediary connects a business with a consumer or a seller with a customer that occurs over top of the platform. So in its purest form, think of eBay, which is not a seller anywhere, but is a facilitator of connecting consumers with the seller or with the businesses. So, but these also apply to a lot of different things. I mean, half of Amazon sales, their marketplace, they have a marketplace. Walmart has a marketplace. And I believe that, I know that states are going to consider these next year. And just one word of caution before, as you go forward, is to make sure you know if you decide to go this route, you know what you're defining as a marketplace, because you could have the scope much broader than you wanted to, and that could be exactly what you want to do. But, or it could be more narrow than what you had meant to, because it could apply to other types of ride sharing. It could apply to like something like Airbnb that isn't actually a hotel. They're intermediary. They're connecting someone, a seller, someone with their house or room with a actual person that's going to go stay there. So I think that may be the intent. So just if you go down to craft that legislation, make sure that you're making sure it's doing exactly what you intended it to do.
I would just add that a couple of states have addressed this. You've got the map up there. I would look to what they've done as sort of a guidance in addition to looking at what South Dakota did, and the marriage of those two pieces of legislation really closes the loophole completely. In theory, there would be a small business exemption in your state for, depending on what you set it at. South Dakota's 200. But if you think about it, the vast majority of true small sellers that are going to be selling into your states are selling on Amazon, are selling on eBay, Etsy, etc. So the combination of South Dakota style legislation and marketplace really hits the sweet spot for closing the loophole completely.
In a point of reference, the Amazon marketplace is I think a little over half of all of Amazon sales. If you go to Amazon.com, that they're only collecting sales tax in 3 states right now for the third parties. That's Washington, Pennsylvania, and Oklahoma. So I think that's where states are going to look next year, not just for Amazon, but for marketplaces across the board. All right, so I'm just going to breeze through the next 83 slides in here, and then, okay, actually, no, we're going to skip this. So this is actually the last slide of this presentation, because this is really where the questions and where we're thinking now is, okay, states have the ability to collect. First of all, does our state have the proper law to do this? We put the notice out there, and when are we going to start? And these conversations are happening in state houses and in tax agencies and legislative fiscal bureaus in every state that has a sales tax, and a couple that don't. And this is what we're going to see as more and more comes along. So in June 21st is the day of the Wayfair decision, so I have a couple of those purple states because they generally believe that they had their law on the books and it was enforceable. July 1 was, you had the first several states, Hawaii, Oklahoma, Kentucky, Vermont. However, Kentucky's law is, with its soft implementation, they're actually not going to go into full enforcement until October 1st, but are encouraging everybody to collect and remit. October 1 is when you have that swath of Midwestern states that will start going into effect. Connecticut's going to go on December 1st, and I think we're going to have another wave of states that are going to wait to January 1st. The yellow states are state commented, and by this I mean if the DOR, the Department of Revenue, has released guidance or notice or said that we're thinking about it, we know, we read the news, we're not under a rock, we're just trying to figure this out. So for the states that are yellow, the states that are blue especially, but for all of these states, if you haven't reached out to your Department of Revenue and asked where they are, what the plans are, going, hey, are we doing this right? Are we posting everything online? Are we providing the clarity that the businesses need? Are we being as transparent as possible? If you haven't, I strongly urge you to do that. They'll actually, most tax people are okay. In the tax agencies.
Thanks, Max.
Yeah, most. They want to do this correctly, and they want to implement it properly. And I've heard from a lot of them that said, we're looking for guidance from the elected policymakers in our state. We're not the ones that make these decisions. We enforce the law. So with that.
I would just add too that at a recent meeting of NGA, there was a similar briefing. One of the attorneys that was party to the case briefed most of the governors who were there, and there was a lot of nodding in the heads in the room. So a lot of your governors have been given a similar briefing and are ready to go on this. And so again, we've had an opportunity to speak with a lot of them, but if you haven't had a chance to talk to your state retail association, they're an important resource, and they're happy to help on any of these concepts or pieces of legislation.
Yeah, Max, I just want to, among the blue and yellow states is Texas. And I just want to commend what Texas did earlier this month, which has put out a communication from the Comptroller of Public Accounts, which basically said, here's a summary of the opinion in Wayfair. We're looking at it, but they said two things that I think were important. One, they said, we're not going to apply this retroactively. Two, you're going to have plenty of notice. Then they also had a section where they had things that they thought their state legislature should consider, because they're obviously taking a close look at how can they adjust their laws and their regs to deal with the Wayfair decision. But I just thought that was a great thing that Texas did. They didn't jump out and just lay out an implementation date or rules or whatever, because they're going to take their time. But they jumped out and they said, we're going to give you plenty of notice, and we're not going retroactive. So it's a 4-page thing. If you have a state that hasn't, one of those blue states out there, I would really commend sort of that Texas approach.
And that's not to say if the states blew up here that there haven't been other comments from elected policymakers in the state. These are more official actions that have been come out and announced. I know that there's other states that are up here that have said so, and you got to go through this and go, oh, my state said something.
Yeah. Well, I was going to say, a couple weeks ago I was at the Southeastern Association of Tax Administrators, and there was a panel of representatives, commissioners mostly, or deputy commissioners from all the SCOTUS states, which basically the southeast states there, and every commissioner was asked a direct question: are you going retroactive on Wayfair? And they all said no, not doing that. So the more states that just come out and just simply say that, the better off we are.
So with that, instead of belaboring, going through more PowerPoint slides, this is actually the last slide that we put up here. And we want to open it up for questions. Obviously, any one of us will talk about this for as long as you would like, much longer. But if you have any questions, please, well, there's a microphone in the middle of the audience auditorium, if you could go to that.
Yeah, thank you. Go home, New Hampshire. We have no sales tax in New Hampshire. Consequently, we have no systems by our sellers to collect sales tax. Under the discussion of undue burdens, do you think they're requiring New Hampshire sellers to have a sales tax system that would comply with regulations that may be as many as 10,000 different regulations would constitute an unfair burden in the context of this decision?
What was the question? Do I think it's unfair?
Well, if you have a state that has no sales tax, and consequently the sellers in that state are not collecting sales tax locally and have no means to collect sales tax either locally or through the internet, and they're now asked to collect taxes for other states and be their tax collector, do you feel that the requirement of asking New Hampshire to collect sales tax without having a sales tax system in place would qualify as an undue burden?
No. I think for New Hampshire residents, they don't have a sales tax today, and whether they buy online or in a store, and they're not going to have one tomorrow. As it relates to the businesses who make the decision to sell into other states, they have to follow the laws of those states, and they shouldn't get special treatment because they come from a state that doesn't have a sales tax. There's software that's been available for more than a decade to help these sellers with compliance, and if they're selling through Amazon, eBay, Etsy, etc., that's all going to be done for them. So no, I don't think that we can create a system where certain states become the Cayman Islands and the online sellers move there and domicile there and continue to sell tax-free. I just don't think that's the way this should work.
I'd like to add that if they happen to be working with the Streamlined sales tax agreement and are working through a certified service provider, when they sell into those states, we pay the cost associated with the software to do that. And it has been available for the last 12 years that I'm aware of with, and has been working. We have over 4,000 vendors that are now working through that system. So I think it helps to mitigate that burden even further when the states pick up the cost for that as well.
I'll just jump in and mention that, the burdens question is one that is unresolved. And that's why, again, I will say, I think it's very important for state policymakers, governors, legislatures, talking with your tax departments to understand that the efforts at simplifying state sales tax systems across the U.S. need to continue until we get to a very, very as simple a system as we can get to.
Because good tax policy is not only good for the businesses and consumer, it's good for the tax administrators as well. It's good for everybody to actually have a better tax system. So, next question.
Yeah, I'm Jennifer Hayes from Kentucky. Should the simplification and thresholds for burden be different for a marketplace seller than what the court acknowledged in South Dakota? Is there a need for it to be different?
I would think if marketplace legislation essentially redefines the platform as a seller, they would far exceed that de minimis amount. So an Amazon platform selling into Kentucky, if the small seller was selling through that platform, Amazon would not be exempt from collecting and remitting on that sale.
I want to jump in on that and just make a plug for our uniformity committee, who had a call and took a lot of input from not state people necessarily, but practitioners and other folks from organizations that follow this. And it was just basically an hour spent sort of brainstorming issues on related to after Wayfair, and a number of those related to marketplace facilitator collection and remittance. And that is something that I think that our uniformity committee is going to be looking at. We're careful. We don't want to duplicate Streamline's efforts, but this seems to be something that a lot of states are very concerned about, and isn't an area that I think Streamline has jumped into yet. So, because there are a lot of complicating issues with respect to marketplaces. Someone said there's a good 200 or more being created. You've got the issue of you've got a seller, he's selling out of his storefront, he's selling on his own direct website, and he's selling on a number of marketplace platforms. And you've got to somehow mesh all those things when you start talking about thresholds and things like that. So there's a lot of work to be done in that area.
Well, I think it just goes to undermine our general message up here has been is that going forward, make sure that you fully thought this out as you go forward, because it is a case-by-case issue. And I think it's less so of dollar amount or transactions. It's more of, have you relieved the undue burden in order to collect and remit our state sales taxes? So if you address those things, I think it's less more the minutia of this or that. It's, okay, we've done these things, we made it as simplified as possible. So your question actually about dollar amounts, I think that is going to be a state-by-state, estimate, or state-by-state as they go forward regarding the marketplaces. Especially, I mean, I guess the advantage of being Washington State or Pennsylvania or Minnesota is that they got to be out there and really define what they believed it should be, and then other states more likely to follow that, I think, because they'll follow that standard going forward.
Yeah, this has less to do, I think, with Wayfair, so it may not be an appropriate question, but where I'm going is that after you have the simplified sales tax coming to your state, is the distribution of that money based on, I think it's done in our state by population, as opposed to where those purchases were actually made and by the people who made them in a certain zip code or a certain area, and how the money is going from collected by the state, simple, not retroactive, all that complying with Wayfair, but then once the state gets it, how that is distributed out as opposed to not being on population and being by the actual people who actually are the ones consuming those, buying those products.
So I think to answer your question, this may not be the most popular at, the local, cities conference, but the states are in the Constitution, localities aren't. Localities are creations of states, and states can dictate how they want to distribute and collect local tax dollars. So that I testified on at a hearing on Thursday in Colorado, which arguably has the toughest home rule. They have different rates, and they tax different things differently across the localities. And to say that your state could pass a law and say this is what we're going to collect and remit. This is the tax base that we're going to have it, and who's going to collect it, and then they will distribute the money back on however the state dictates it under the state, and move it down that way. I think it's completely fine to do that. I think that's more of a level at the state of how they decide to go forward on that area internally, rather than it is for me to sit here and to say, how are you planning to do that?
That was one of the things that was asked of Wyoming when the news that Amazon was going to begin collecting voluntarily in the state of Wyoming was, okay, are we still going to get the same tax dollars in each county that we would have otherwise? And I said, nothing changes. They utilize the same zip code address that we provide for other sellers to determine what the sourcing for that tax should be. I ran a number of transactions, not only through myself, but also from my family in other parts of the state, and they actually got it right. So it's if I'm in a 6% county, we get the distribution rule is exactly what is in effect in that county for any sale, regardless of whether it's
general sales tax. But we do have some of our local resort communities that are authorized through a local option to have local option resort sales taxes. So I'm wondering if this ruling has any implication there to local community sales tax. And then my other question is, Montana does have a corporate income tax. And as far as collecting those public revenues, will this support the argument about business presence in a state, regardless of whether there's a bricks and mortar corporation in the state?
Thank you. That's a really good question, actually. And I think Senator Heitkamp, I spoke on a panel at the Brookings Tax Policy Center the Tuesday following the Wayfair decision. And ahead of it was Senator Heitkamp from North Dakota who spoke. And she actually referenced a Montana senator who said, oh my gosh, you guys are trying to enforce your sales tax collection on our state businesses. And then Senator Heitkamp responded in with, what are you doing to my businesses regarding to corporate income tax? Like when they're not there. It's the same thing. It's the idea that physical presence is no longer necessary in any types of state tax to avail yourself. And that's following either through Supreme Court precedents or others that you have to, if you avail yourself to a market in a substantial way, whether it be income or whether it be sales, that you have met the burden level, the standard in order to have to collect or remit that state's taxes, regardless of what they may be in that regard. Does that address your question?
Yes.
In terms of your local, the local resort fee question, I don't know.
Don't pitch that one to me, man.
Oh, I was trying to defer it off.
I wanted to talk
still
about
out.
the income piece.
Oh.
The local tax issue is it's a thorny one. So I think there are other people on this panel that are more expert with respect to that, but I just want to point out, and I beg your indulgence for a minute as I engage in some lawyer speak, but there's an important Supreme Court case called Complete Auto, and Complete Auto laid out a four-pronged test for testing the constitutionality of a state imposition of tax related to interstate commerce. Substantial nexus is the first prong of that test, and because Wayfair links its holding to the substantial nexus prong of that test, it strongly suggests that it speaks to nexus questions for any state tax, not just sales and use tax. So that's the answer I wanted to give you on the income tax piece.
I'm sure our auditors will love to hear that.
Thanks.
Well, and I guess I get the thorny question, if you will, about the local taxes. I think your question is probably tied to the remaining pieces of the decision that was not addressed in Wayfair, and that is whether it would create an undue burden on a seller to collect a local tax and not at the state level. In other words, what you're saying is these are taxes that are imposed at the local level, not at the state level. The question would be, and this is something that would probably be for a court to decide, unfortunately, at this point. They didn't point to that issue as it relates to local administration of the tax. They talked about one of the things that may reduce burden was state level administration of the tax. I don't know whether Montana would be willing to take that over for the locals as it relates to remote sales or not, but it may be something that would at least demonstrate a reduction in the burden, if you will.
Thank you.
Hello, Reynold Neseba from South Dakota, state senator from South Dakota. It's more of a question to see if other states are wrestling with the issue that we are in South Dakota, which is when we joined streamlining back in 2006, it forced some of our cities to increase the tax on groceries, on food. So in South Dakota, in Sioux Falls where I live, the sales tax on food went from 1% to 2%. Other cities like Rapid City and Mitchell didn't tax food at all. They had to go from 0 to 2%. I have a bill that I would like to bring forward to use our remote sales tax gathering to reduce that sales tax on food, as some legislators promised they would do, because the idea that if we do the streamlining at some point in the future, we'll be able to finally eliminate the sales tax on food. I'm curious if there's other states thinking about this, and if so, if you had any recommendations on how to approach that issue.
Well, you can spend your money any way you want. So that's not my decision. That's what I can tell you is that Utah, 10 days ago, I believe. I'm sorry, my days are running together. They passed South Dakota's law, said they're going to have it go to effect January 1. They're a streamlined state. They're going to make it revenue neutral and actually use the extra revenues to actually cut business input taxes, which, generally believe borrow the base, lower the rate, don't tax business inputs. The state of Iowa earlier this year perhaps had the biggest income tax cut of the last several, I think it was $2 billion over 6 years. And they cut their income taxes by broadening their base to include digital products as well as remote sales. So they're really to broaden and bring it down. I think that's where states are going to go next year. Now, whether or not they're all revenue neutral, they plan on spending the money on schools or roads or transportation because the federal government didn't come through on an infrastructure package like they said they would. I think that's obviously up to each elected policymaker and where they plan to go. But I would be shocked if we don't see more revenue neutral legislation in this arena going forward.
States' rights.
Hi, I'm Mark Barnes from Arizona. You touched on this in one of your last answers, but sourcing. Is there anything in this decision that ties the tax rate that would be charged to the address the delivery is made to? In Arizona, we have cities, counties, and the state all have tax rates. So the tax rate at a particular address may vary. Is there anything that ties the sourcing to the address of the delivery? And second question, obviously, we're a blue state up there. Is there any recipe you can give us to get to the point where we're implementing this decision in Arizona? I mean, do we need to enact an economic nexus law like South Dakota? Can you give us sort of a recipe to get there?
I would say take the South Dakota legislation and the marketplace legislation that's been passed in a couple of different states and do your best to merge those two pieces of legislation, and that will get you 99.9% of the way. And I think if you know Michelle Elmer, who's the head of the Arizona retailers, she'd be happy to work with you on this. I know she's been a champion on this issue for a long time, but I'll happily mention if you want to give me your card to reach out to you.
And for your specific question related to sourcing, it's destination. It's where the product is being delivered. And if you talk to if you get any software provider that's selling this software to tell you that they cannot properly collect and remit sales tax everywhere in the country, no matter where it's sold, please let me know who that is. Because they all are saying, these are technology companies that follow this, and in the world where, I land on the plane in LA and I immediately says, these are all the friends and where they are, and this is where they like to shop and they know everything about me, but yeah, we can't figure out the tax rate that didn't change for the last 4 years. I think that's kind of disingenuous. The software works. That being said, there is legislation, actually the NCSL City Committee on Communications, Financial Services, and Interstate Commerce about 2 hours ago passed a resolution to define clarity for sourcing for digital products. So that were to be, we are increasingly becoming a service-based, digital-based economy, which is why I believe the digital tax world will be a very big issue for states the next couple of years because their bases are shrinking for sales taxes. So, but if you buy a product, so I live in Northern Virginia, I pay for an app on my phone here, and then it's based in the apps on the server and on another state who can tax it. Well, right now, theoretically, they all can. And I think that is the digital arena, because we're not actually shipping it anywhere, it's instantly on my phone. That is where the sourcing clarifications are really necessary to prevent double taxation and pyramiding on top of each other on digital products. But that really is not an issue related because it's a tangible personal property. When it's shipped and where it's delivered to, we have the address, we have the zip code, which should be able to properly collect and remit the tax.
Joe Crosby with Multi-State Associates. I just wanted to revisit this New Hampshire issue briefly because there's a really interesting link between South Dakota and Wyoming, in fact, and New Hampshire, in that they are virtually mirror images. South Dakota and Wyoming have sales taxes, but they have no corporate income tax. New Hampshire has actually two business taxes, a business profits tax and a business enterprise tax, but no sales tax. So the concern has been raised that New Hampshire sellers who are unfamiliar with collecting sales taxes will now, if they sell in another state, potentially be required to collect and remit those taxes. So collecting taxes from someone else, it's not a deprivation of the New Hampshire business's property. They're just simply collecting and remitting. In 2007, New Hampshire changed its own law to adopt economic nexus, for the business profits tax, which means that South Dakota and Wyoming businesses who never travel into New Hampshire but make sales in New Hampshire are required not only to pay that tax, but to comply with a tax that almost any tax professional would argue is much more complex and difficult to administer than a sales tax. And it's actually depriving them of their property. They're the ones paying the taxes rather than simply collecting tax from somewhere else. So it's really interesting because I do understand New Hampshire's concern about its sellers not being exposed, but it is already requiring non-physically present businesses to comply with its own tax laws. Thank you. Just a comment. You can add, further comment if you'd like.
You finish it with like saying, do you agree? Or something like that.
Dennis Brown with Equipment Leasing and Finance Association. We've been involved with the SALT Task Force and Streamlined since the very beginning. And for some people in the audience here that represent a business that does nothing on the internet, that's us. So why are we so concerned about this issue when in our industry we finance leases of commercial equipment? You don't do anything on the internet. And the reason is the Streamlined sales tax agreement that's been hammered out, we've been working on for 20 years, I guess, defines products. Ask people from the candy industry if they like the definition given their product. In our case, we sat down over a 2-year process and hammered out the definitions that are of leasing and related to equipment leasing. So if you're sitting here and you're saying, boy, I'm glad we don't sell on the internet, this is all so confusing, you might want to take a look at the Streamlined sales tax definition section. It's a 364-page document as of last week when I looked at it, and it continues to grow because your industry, which doesn't do anything on the internet, might be defined, and you ought to be sitting at the table when it happens. Just my comment.
Thank you, Dennis.
Hello, my name is Christian Beltran. I currently work with the California State Senate. I worked with Senator Steve Glazer this year on a constitutional amendment, which is kind of unique to California because the way that the allocation of these revenues are constitutionally protected in California. And what this constitutional amendment would have done is change the way it's allocated based on point of sale, and then now changing it to point of destination. And one of the biggest hurdles that we encountered by changing it to point of destination is the fact that the localities have these tax share agreements as a form of an economic development tool. So with the Wayfair decision, I mean, what are some of the implications that you see for some of these localities that have these tax share agreements? And then additionally, I think we kind of touched upon it earlier, what would be a good allocation method going forward, considering that these new revenues are coming? I know it's more like up to the states to determine, but as you've seen in South Dakota, what is something that you recommend?
Well, I think I look at it a little differently. I think if I look at it as an opportunity, this is an opportunity. This is an opportunity to actually address the issues of part of that are in the complexities in sales tax and tax codes in general that weren't necessarily there. That over time we have new revenues coming in. You're able to use that to address problems that maybe would have been costly before. That localities, you can, there's the carrot stick syndrome, which is, hey, like, do you want to, in order for you to collect these dollars, you have to do these things, and I think you can allow them to keep their autonomy, but they won't be able to get the taxes that, and eventually they'll come along. And I think that those are the kind of issues. In terms of allocation themselves, I mean, I'm a believer that the tax rate should be applied to the place where it's delivered, and that's where the money should go. But in terms of actually dollar amount allocation, that's definitely not for me.
Okay, I mean, just to follow up on that, because generally the sales tax is based on where the impact is taking place, and so a lot of these cities where the warehouse is located, they argue that a large amount of the impact that is related to online sales is coming directly to the city. So that's what I'm trying to figure out as to what would be right balance.
Yeah, I think that there's different ways to look at a lot of different things, and I don't share necessarily that viewpoint from the localities.
My question's for Max. In terms of going forward and looking at the next year and beyond, I know that you guys said that the Supreme Court case provided a kind of roadmap to see where they can go, and I know that we have the lists of where states are and what they've said already, but you said two things that stuck out to me, one about marketplace laws and the other about revenue neutral legislation. So can you tell me a little bit more about those two items and why you're expecting in the next year to see more of that, and anything else that you're expecting going forward?
Sure. Revenue neutrality, I mean, that's obviously a political decision. I mean, what do we do with money? I mean, if money wasn't an issue, then politics would be a lot easier for everybody. And whether or not we want to use these new revenues to spend, and I think just the way the political climate is across the country, a lot of states, I think that revenue neutrality is where a lot of states want to go. Now, be able to determine that by state could be difficult. I mean, I recommend, personally, that you would set up like a reserve fund and figure out how much money you're bringing in and a way to do that, and then use those revenues to actually then, lower the rate or whatever you plan on doing with it, because it's just, I don't believe a good sound policy to just preemptively think we're going to cut this much or raise this much and vice versa. So I think that's we're going to see that. I also think that in terms of marketplaces, I've said this for several years. I've said, when this issue is probably about marketplaces where this issue ends up, because, I mean, we're so, I don't think we appreciated enough of how fast commerce and the way we buy things change. That how long ago was it that you had to go to the mall in November in order to get in December to go Christmas shopping or to get holiday shopping and presents? I mean, it wasn't, this wasn't millennia ago. This was, the crazy time of 2004. It's rapidly changing so quickly that we go, and as soon as we get comfortable with this, some form of technology, then other innovation and research changes the way that that's delivered. And when it comes to, and this is generally across the digital economy, is that for a tax department to be able to define what is a service, what is a product, what is this or that, they don't want to have to define these things. They don't want to have to go through and figure out if this was taxable or not, because then they're screwed either way, because they're either, you didn't collect it, well, why are you not collecting taxes as you should, or you are collecting it, and while and let it, this is why I tell tax administrators to go talk to elected officials, because those are the kind of hearings that are bipartisan that everybody loves. Why did you do this? So I think, so marketplace is one of those, and it's just the intermediary platform, whether, as I say, it's a, you can apply it to a lot of different things. Airbnb is a marketplace. Uber doesn't have any, Uber does not, driving you around. They don't have cars, they're connecting people. Airbnb is not hotel rooms, they're connecting people. And same thing for sales. So I think the panoply of what's going on in the digital world, that marketplace is where it's going, as well as from the conversations I've had from numerous state lawmakers throughout this year, preparing for next year, it just seems inevitable to me that that's where we're going to end up. And I think the question to look at is, I mean, to me, there's not a question of whether or not these marketplaces have liability. It's the degree. The question is the degree of liability you think they have, and that's where the focus should be on. And the question then comes down to, do they collect it, or do they, if you're selling over the platform, do you have to collect and remit? And I think that's a political decision again.
Yes, Virginia, following up on the California question, we're also one that, since our local sales tax is uniform throughout the state until just a couple of years ago, there's one exception in one area of the state, we've never had the issue of whether or not the tax was at point of sale or where the person lived, even if it was delivered, because it was all the same. It always went point of sale. If we hold on to that, because it makes a huge difference in local revenues, will there be any problem in our conformity where on this issue as far as the tax being collected at the point where I'm going to argue that the person, the customer on the internet initiated the sale, and it's so therefore it's where they live? Will we have any problems with how we word our conformity with what our tradition has been?
And you're talking specifically about a remote sale?
Yeah, again, we have an existing structure that has a lot of reason for staying in place. So if we, in our conformity, where now the structure says you're going to tax at point of delivery, if we define point of delivery to be point of sale so that we don't interfere with our existing structure, will we have any legal problems with that?
Actually, we've got several states that are, for intrastate sales, are point of sale based. And what they have done, and these are streamlined states, that actually have gone to pointing to the point of delivery, if you will, or the destination of that sale for interstate, meaning in most instances remote type sales. But if you're, I don't think you'd have to alter your state's viewpoint there, and could probably still source the transactions coming into your state to that point of delivery, because that's probably the only place that makes any sense for it.
Correct.
I agree.
Thank you.
Obviously, everybody, we're keeping you from a reception or something, and we're not going to do that anymore. Thank you guys for hearing. We'll be around to talk. I could talk about this more than you want, and I appreciate it, and I hope everybody enjoys the rest of your evening.